Welcome, everybody. Thanks for joining us this evening. I'm Fiona DiDomenico, and I'm a regional president with the Castle Group. For those of you that may not be familiar with Castle, we are a locally owned Florida company based here in Florida. We manage 300 plus associations across the state, and we're also in Texas. So if we have anybody from Texas who's joined us today, welcome. Castle's a little bit unique because what we do is we specialize in associations where we can put a team of people on site, or at least a manager on site. Most of our associations that we manage would be highly amenitized. A lot of them are gated. A lot of them have food and beverage. We've got full lifestyle directors at a lot of our properties. And we've got a lot of specialists. So if there's anything that we can do, if you have questions for us, please feel free to reach out at any time. And you can reach us at info@castlegroup.com. So I wanted to welcome everybody and welcome our experts. We have Adam, Nagar, and Jim here today. And Nagar, I'm going to turn it over to you for a minute. If you could introduce yourself, a little bit about Assured Partners, and then pass it along to Jim.
Sure. Hello, and thank you for joining us. My name is the most difficult one of the crew. It's Nagar Sharifi. I've been specializing in insuring condominium and townhome and large communities for 13 years now. And between my partner, Phil Massey, and I, we work with over 400 communities. So we say, and it is true, there is not a claim or scenario that we have not seen or been through. And I appreciate being on the panel today.
Excellent. Thanks, Nagar. We appreciate you being here. And Jim, are you there to say a quick hello and introduce yourself?
Sure. I'm Jim Pritchard, and I'm the managing partner of Ball Janik. I'm actually sitting in Portland, Oregon right now because that's where we're headquartered. And I split my time between the East and West Coast. So I've got my cold weather Portland lumberjack attire on, and I will be on mute quite a bit because I actually have quite a bunch of home improvement projects going on and contractors walking around my yard. So if you see any movement in the windows behind me, I'm not being blocked or about to be assaulted. It's just contractors, and hopefully they won't make too much noise or cut my Wi-Fi connection. As far as Ball Janik, we are a real estate, land use, construction, and insurance recovery law firm. Our Florida operations are Orlando and Miami. We have over 20 lawyers in the state working primarily on construction defect and insurance recovery litigation. I travel throughout the state handling those matters for clients and team up quite a bit with our hosts and the person I'm going to hand it over to in just a second, Adam, with the Arias Bosinger General Counsel firm. And we like to team up with good lawyers like Adam to represent communities and to work with management teams on the types of claims that we handle. And we'll talk more about that later. I'm a trial lawyer by training. And so when I participate in these types of presentations, I'm hopeful that you won't hear from me a whole lot. Life is good when you're hearing little from the trial lawyer. So I'll hand things over to Adam, the general counsel lawyer, and he'll take it from here, and you'll hear from me mostly at the end of the presentation briefly.
Great, thanks, Jim. And again, welcome to everybody. And I want to thank Castle for putting this together. We've done a few classes like this with Gianna and Fiona. And I think it provides a great value to Castle's communities, but also communities just in the Central Florida area that are looking to learn a little bit more about how to run an HOA on some particular matters. I chuckled, Nagar, when you said you've seen every claim and scenario imaginable, because that is certainly true now after a global pandemic has come through. So you are, without exception, you can say that, I'm sure. Just very briefly about me, I'm a board certified specialist by the Florida Bar for condominium and plan development law. I, along with three other of our partners here at Arias Bosinger, Frank Lacquaniti, Sonia Bosinger, and Carlos Arias, are all board certified in this specialized area of the law. There are less than 200 attorneys across the entire state of Florida that are certified in that area as specialists. So we're very proud and fortunate to have 4 within our firm. Our firm covers essentially the middle part of the state and then extending up the coastline to Jacksonville. So basically Jacksonville down to Melbourne. We have an office in Melbourne. One of our main offices is in Central Florida in the Orlando area. And then we also go over to Tampa as well and everywhere in between. Our firm focuses almost exclusively on condominium and HOA law. And that addresses essentially every aspect of community association law, covenant enforcement, collections, general counsel opinions, amendments to the declaration, so on and so forth. And certainly, as Jim referenced before, we partner on some claims when it comes to property damage issues. Simply because Ball Janik has proven to be a extremely valuable resource for our clients as well. So we like to partner with them and have a good working relationship. Before we jump into this, I do want to just address a couple of things. One, please ask questions throughout this presentation. It's scheduled to be a 2-hour presentation. We're going to try and get you out maybe in a little bit earlier time than that and give you plenty of time for questions and answer. But it's going to be a lot more interesting and engaging if you guys submit questions, and Fiona will be sure to monitor those and pepper those in during the presentation. The next thing that I want to address is that this class is focused on the turnover process, a practical approach for a smooth transition. There may be some of you on here that are thinking that this is for a turnover class from one management company to another. That is not technically what this class is designed to address. It is more focused on a community transitioning and turning over from developer control. In other words, the developer appointing directors on the board and then transferring control of the association to the homeowners. However, before you all go signing off, please stay with us because there are a lot of things that are going to apply across the board. And really what this class is about is an overview of what the core aspects of community association governance is going to be, whether it be at transition or throughout the lifespan of the association. There are, of course, a few issues that are going to be very specific to turnover, but by and large, this is good industry best practices for anyone involved with community associations to review. So without further ado, let's go ahead and roll into it here. Okay, turnover from developer control. And if you don't have a copy of these slides as well, we're happy to get you a copy of the slides, and we might even be able to do that during the Zoom session. I'll let Gianna work on that in the background. But what is turnover or transition? It's the process by which the right to control the condominium association or HOA governing a community is shifted from the developer of the community to the homeowner purchasers. That's a very technical legal definition. But in practice, it's a mistake to think of turnover only in terms of that membership meeting. And what we typically find is when someone says turnover or transition, they literally think of just that meeting. The meeting that the developer calls, says we're going to have a turnover meeting. You show up, hopefully you meet quorum, you elect some directors, and that's it. But to do it smoothly and to do it in the best way possible to the advantage of your community, I like to make what I refer to as the marriage analogy. And this is, you can get to the ceremony for those of you that are married. And it's a hectic day, but it's one day. You say, I do, you sign the marriage certificate and you're married. But anyone that's been through that process knows it's a lot more than just that one day. And that ceremony is just like the turnover meeting. It's the culmination of months of preparation, sometimes years. And that's just kind of the keystone event that marks the official legal transition. But what we want to talk about to you today is not only the preparation for that, but also during turnover and immediately following that meeting, what you need to do as a community to set yourselves up for success in the future.
And Adam, while you're looking at that, it's one of the myths that we often hear, out in the field. People will say, I can't do anything until turnover happens, or I have to do everything, before the turnover meeting. So I think you're going to cover that. So that'll be great, because that's definitely one of the things we hear from a property management standpoint, one of the misunderstandings about turnover.
Absolutely. And that's, in fact, the very next slide, because one of the, I won't say misconceptions, because there are often disputes that occur with developers, some worse than others, but there are always things to work out. It's just like when you have like Jim's doing the contracting work at his house. Surely he's going to do a walk around to see what has been done. There might be a punch list. And that's just the nature of this process. When you develop a community that has 1,500 homes, there are going to be some issues that need to be addressed, or you develop a high-rise community. But like it or not, the developer is still in control of the association prior to turnover. And in my practice specifically, we predominantly represent community associations after turnover, but we do represent a number of associations prior to turnover as well, where developers have elected to hire us as association counsel, independent of the developer's own in-house counsel. And what we get in these pre-turnover meetings is often a lot of animus that's being expressed by the membership and the community towards the developer prior to turnover. And I think there is a misconception that by taking a hardline position against the developer prior to turnover, that you can somehow negotiate a better turnover for your community by applying pressure to the developer ahead of time. And while there are certainly things that you can raise as a membership, my recommendation just generally is to strive for a cooperative relationship, because there are a lot of things that can be done ahead of time, ahead of that ceremony, that can benefit the community in unique ways that are only achievable, or vastly more easily achievable, while the developer is still in control and involved in the community. Not the least of which is amending your governing documents. And what happens just from a industry standpoint is that developers will often use very similar governing documents for multiple communities, particularly large developers, whether they be regional or national home builders or developers. They're going to use, form documents that are altered to some degree from community to community, but they're not going to necessarily be tailored to your individual community and the needs and desires of your residents. And so surely in situations where there's been a long pre-turnover period, but really in any period, there are going to be issues in your governing documents that ideally your association would like to see fixed or changed for the betterment of your community. And in those circumstances, if you have let's say you have a 75% amendment approval threshold for your entire community, meaning you need 75% of all of those 1,500 lots or 500 units to approve that amendment, it's going to be difficult to achieve that threshold. Whereas prior to turnover, typically developers have reserved the right and maintained control to amend the governing documents without membership approval. And so if you have a cooperative collaborative relationship with your declarant, there are often times things that they will be willing to adopt for the community governance after turnover occurs. So I think that's just conceptually something that you need to keep in mind. The other thing that I address at pre-turnover board meetings or membership meetings, I'm thinking of a few that I just attended in Tampa recently, where even sitting, shoulder to shoulder with a vice president of a home builder and development company over there, who is appointed to the board of directors on the association. Again, I'm sitting there as association counsel, and there was clearly some complaints from the membership as to what had occurred within the community up until that point. And my response to them was, to address those things as clearly and directly as possible, but to also try to still the waters in those situations, to let them know that there is a possibility to pursue those issues with the developer in a more combative situation after turnover occurs. And that's really the time where that phase typically occurs. Of course, there are exceptions to that, and various circumstances where you need to address that with legal counsel. But for the most part, the declarants that we work with don't mind hearing us say that because they agree. You're not going to avoid a dispute between the association and the developer simply because you delay it to immediately following turnover for the most part. So that's something just conceptually to keep in mind, that you can kind of pace yourself in the issues that you want to address and work collaboratively with the developer prior to that turnover. The other thing that can be implemented, again, prior to turnover, is establishing what people refer to as a turnover committee. I'm curious to know whether or not we have any turnover committee members on the broadcast tonight, whether that be official or informal, whether you've grouped together with some neighbors to try to get involved ahead of the turnover election. And what we often see is that those turnover committees end up being essentially the board that is elected. And whether that is because they're the only volunteers willing to get onto the board at turnover, that's something that we'll have to read between the lines. But it's really a great idea, because, and this is the same reason so many communities try to implement what are referred to as staggered terms for their directors, and that's institutional knowledge. If there is going to be a wholesale transition of directors that were appointed by the developer, and now all of those directors are going to resign, and new directors that are homeowners are going to be appointed, you still want to have some working knowledge of what the community's operations have been up until that point and as they exist on the date of turnover. And that is, anything from, knowing your vendors, your management company, certainly your attorney, your accountant, and landscape architect, so on and so forth. But knowing what your governing documents are set up as. Sometimes these larger communities can have some very unique structural aspects to their associations from a corporate law standpoint. There can be multiple declarations that are governed by a single association. There can be neighborhoods within your association. You can have a master association and sub-association situation. And you can have the plain vanilla HOA and members, and that's it. But it's good to become involved and get that working knowledge, so you can at least hit the ground. I don't want to say running, because you're probably not going to hit the ground running, to be honest, but you can at least hit the ground walking at a leisurely pace.
Adam, it's a great point. Some of the questions that were coming in were kind of around, does every turnover result in a lawsuit, and should every vendor be terminated? And I think what you're kind of saying is you clearly know not every turnover results in a lawsuit. That's certainly not the end game for anybody, right? We all want to cooperate and try to work together. And then again,
Yes.
from a vendor standpoint, you want to kind of make sure you don't lose all the history of the association, and you want to hold your vendors accountable and make sure they understand, what I can tell you from a Castle standpoint. When there's a turnover situation, we say to the turnover committee and to the boards that, we're treating you like a brand new account, because what the developers, strategic vision was for the association is very different when it turns over to a resident
Absolutely.
association. So those are all things to consider.
Yeah, and that's a great point, Fiona, as well. And again, I bring up that scenario, and this is something that is, I think, is sometimes difficult to see from a member's standpoint, because in the pre-turnover phase, associations, particularly at the very beginning, are on, almost an autopilot type feeling. The owners purchase within the community, and they aren't involved on an operational level, so that any action that's being taken by the association all seems like one entity. And that's the developer, that's the management company, that's legal counsel, and even the vendors, maybe the various builders that are involved in that community. It all seems like one entity, and it truly is not the case. There are multiple entities that are working independently of each other. So my advice generally to all community associations approaching turnover is to not upset the apple cart just for the sake of upsetting the apple cart. First, it's good to get a lay of the land, have an insider evaluation of your current vendors, of your the aspects of the community, even to the extent where if you were anticipating, filing a lawsuit right off the bat, certainly there are legitimate claims to be made against developers on a number of occasions. We're involved with them. I'm sure Jim can attest to that as well. But there are just as many situations where we are counseling new boards that it may not be a good idea to do so, or there isn't a strong case, or it's not worthwhile. And the only way to get that information in a attorney-client privileged way from the association's perspective is to be on the board, is to be involved from a corporate level. So when you have a general town hall style meeting or membership meeting where people are free to make accusations or complaints or raise questions in that form or in that forum, it is sometimes difficult for the professionals, including management, to adequately answer those questions in that context. And it requires someone being appointed to the board. So once you get on the board, you rely upon your professionals, look into them, do your own vetting process. And we'll get into evaluating vendors here in a moment. But that's something that, you want to, not just change for the sake of change. You want to, act with intention and mindfulness and what changes you're looking to make and what actions you're looking to take.
And we have, just so you know, we did get a couple of people that chatted in, Adam. So we do have some turnover committee members from
Great.
a condominium association, and
Wonderful.
some
Well,
transition,
welcome.
some transition committee, and a chairperson from a transition evaluation committee. So we've
Fantastic.
and
Well, this
we
is
do
very
have,
timely for you guys.
yeah, we do have some questions. So specific questions. Let me know, Adam, when you want me to pepper those in, and I'll
Let's go with some now.
Okay, perfect. Give me one quick second here. So we've got a question. It says, what suggestions do you have for a transition committee faced with the developer selling the property to another developer 6 months prior to turnover?
Great question. And for the most part, there isn't much that you're going to be able to do about that. And from that's a general answer, but that's not an uncommon event. And so it may seem odd that would be happening right before turnover. But the reality is declarants acquire and sell properties within communities on a fairly regular basis. Whether that, and certainly we saw a lot of that immediately following the financial crisis back in 2007, 2008, 2009, where there were foreclosures happening in mass scales, and there were even bankruptcies occurring, and their subsequent developers taking control of associations in that way. But just from a practical perspective, what's happening, and we'd obviously need to look at that on an individual basis. The facts matter in every situation, but for the most part, that's simply a transactional matter between the developer and another builder. There can be implications that come up with that in terms of whether it triggers assessment liability for that builder that is going to be purchasing those lots from the developer, whether or not they're transferring and assigning declarant rights to that builder as well, rather than just selling those properties to be built by a different builder.
And Adam, how do they, because I know that's always a concern, how would they go about verifying that? Is that something the new developer would put in writing for them, or what is the appropriate way to verify that?
Well, a good way of doing that is to submit an official records inspection request to the association, because certainly if there's going to be a transition, including the assignment of declarant rights, that's going to be something that is typically recorded in the public record, but you can access that by submitting a written request to inspect the official records of the association, including anything related to that transfer. But to get back to the primary point of the question, what can the association do, or what can the transition committee do in that context? And the answer really is, unless you guys have a different take on this, there really isn't anything you can or even should be doing at that point, other than being aware of it and monitoring it. Again, just because things are changing close in time to the actual turnover event doesn't mean that it is wrongful or even that it's going to harm the association. It's just something where you need to be aware of it. And then once transition occurs formally, certainly speak with your association's legal counsel about that, so that it can be evaluated a little bit more closely to make sure everything either was done correctly, or make sure there aren't any unintended consequences that came from that transfer that may not have been accounted for by the developer and the builder involved in that transaction. But great question. Great question.
Adam, this is Jim. Can you hear me?
Yes.
I would add, I think the only time that a board and membership would want to be concerned, and we've run into this quite a few times in the last couple of years, is where you have a developer transferring ownership to a different developer, and that different developer intends to substantially change the nature of the subsequent development. Oftentimes before the transfer, there will be public notice of this intent, because when developers are doing deals with each other, they're saying, hey, this property could have a higher and more profitable use to you if it was rezoned or there was an entitlement to develop commercial. And in this particular larger community outside of the COA or the HOA, there's a desire for business because this is a bedroom community and they want shopping centers or restaurants or something. So we do have clients who occasionally have a substantial land use issue that they're confronting. And in those circumstances, the board and the membership actually does want to take advantage at all stages of the process to be active in that change of development entitlement and to have your voice heard, because you may not want a change from a mixed use development to purely residential or what have you. And that's the only time where I would caution a little bit more diligence, because I think almost always a subsequent or a different developer coming in is a breath of fresh air and not really much of a consequence to the community other than different people building out the remaining lots.
Yeah, and that's actually, yeah, no, that's a great point, Jim. And that's particularly for that circumstance, that's when you need to be in early and in great numbers in those development review committee hearings at the county level, so that when they're changing that land use, you're not necessarily even evaluating that from an association level as you are an owner level, going to say, hey, we don't want maximum density housing right next to our half acre lots. That's not what this was intended for. So that's really a great point. So just moving on for the slide in front of us here, and we kind of mentioned this as well. You'll note that it's the phrase that I use here is evaluate and retain true community association experts to rely upon. And there's a lot of hidden meaning in that phrase. Evaluate certainly is what Fiona and I were speaking to earlier about not just making a change just to change. Truly evaluate, educate yourselves on the various professionals that are out there. And if you need to make a change, go out and retain new professionals, but if not, become familiar with the ones that you already have. But make sure that you're retaining actual professionals and experts in this field, because one of the old jokes that we had as community association attorneys in years past, at least, was that everyone practiced community association law. And we would always put the air quotes up because it was everyone dabbled in it. And just like everything else, not just community association and not just law, everything is a specialty now. There is so much to know in every industry that we've become a specialist economy. And this is no different. The laws have changed in incredible ways over the past 20, 15, 10, even 5 years. There are a lot of changes that have been made in this industry. And unless you are involved with this type of law or management or insurance on a day-to-day basis and dedicate yourselves to that continuing education, you're not going to be on the leading edge of knowledge. So you don't want to just go out and type in Google, HOA CPA or HOA attorney. You actually want to, look for independent certifications and specialties. There's PCAMs for property managers. There's CERMs for insurance agents. I mentioned being board certified with the Florida Bar for attorneys. All of these are trade organization verifications independently that someone is specialized and knowledgeable in this area. So make sure you do your due diligence in retaining the appropriate professionals. Okay, so moving into, and actually before I get into this corporate matter, I just want to reiterate, the reason that you're wanting to rely upon or hire true experts in this phase of your community is that it's essentially the most important time for your community, the most impactful time that you can have in your community for the foreseeable future. It can make or break your community, whether you handle the turnover period and not just the actual day, but the months and years surrounding that process, both financially, from a covenant regulation perspective. It is critically important that you prioritize and rely upon professionals to guide you in this process. Because we have seen, unfortunately, many associations that have not retained independent expert professionals to guide them in these times. And you can, as a community, forego legitimate claims and opportunity to be able to have a positive impact on your community. And that includes the pre-turnover collaboration with the developer as well. Because
I was just going to say, Adam, sorry to interrupt, but if I could add to that, I see from our end, the transition committee has such a huge impact on not only from a business standpoint, how the association is run, for the next 5 or 10 years, but really the tone of the neighborhood and the sense of community and the sense of neighborly, togetherness and calm and all of those things that really make living in your community enjoyable. And it starts with the tone and the approach that the transition committee takes, and it goes from there. So not to scare anybody, but it really does. It makes a difference. And I really encourage you all that are joining us today as transition members to really think about that, because you are setting the tone for what it's going to feel like to live in your community in the future.
It's really a great point. And I think part and parcel of retaining, as an attorney, in our training, we focus a lot on the word professionalism. And I think that comes into play here with transition committees as well, to have an aspirational goal for professionalism. Not saying that there aren't going to be disputes, but that you can address them in a reasoned, focused way that isn't bombastic, that isn't distracting in how you speak about it with your community. Because, and this is something where Jim and I have counseled mutual clients that end up having, in the circumstances where there are significant issues, property damage issues or defect issues within a community. Sometimes people just want to, hit the streets, hit the sidewalk, tell all the neighbors, hey, this is what's happening. Let's get the pitchforks and torches out because it's time to roll. And that is not the most prudent approach. You need to take a methodical approach. You don't want to yell fire in a crowded theater is a phrase that we use often in those situations, because these are often very complex issues that you need to rely upon these professionals for, where if you are making a lot of noise, you might be missing, looking into a, deficit funding issue, or you might be missing the fact that you have a 90% of all voting interest amendment requirement that essentially guarantees that you'll never be able to change your governing documents in the future. And you want to be able to get that changed with the cooperation of the developer prior to turnover. So just keep that in mind. Okay, rolling into corporate matters. This is, the director turnover election, the timing and procedures. So this is governed by Florida statute. For condominiums, it's under Chapter 718, Section 301 Florida statutes. And for homeowners associations, you are governed by Chapter 720, Section 307. These are the turnover provisions within those respective statutes. And then from a supplemental standpoint, condominium elections are also governed by statute, which would apply to the turnover election as well as Florida administrative codes, and that's the FAC there. From an HOA standpoint, HOAs, their elections, and I give entire classes on annual meetings alone and elections alone. So I'm not going to go into that much detail here in these slides. But for HOA elections, you really need to focus on what is provided for in your governing documents because there is no statutory default in Chapter 720 for HOAs and how an election is supposed to be conducted, with the sole exception of if you use secret absentee ballots pursuant to your governing documents. And in that sense, you end up using a 2-envelope system, which you all are probably familiar with. But it essentially involves a smaller inner envelope, the ballot envelope, where you put an unmarked ballot inside that envelope, seal it up, and then put that sealed envelope, unmarked, inside an outer envelope that has that you can sign and put your name and address on that outer envelope. But for HOAs, that only occurs if you have secret absentee ballots provided for in your governing documents. And incidentally, that's something that you may want to address with the developer ahead of time as well, because this is an area where, to be quite honest, developers are not that great about the foresight of these elections because they don't have to deal with them when they're in the community. Yeah. they just appoint the directors while they're there. This happens after the fact.
This is a big one, Adam, that I see from a management end, and I highly, highly, highly recommend do not go this alone on your first, election. Definitely get with your, your association attorney and your management company. Make sure the attorney blesses, the process you're going to go through, whether it's an HOA or a condo, because even in HOAs, typically they're a little less, restricted. However, as you mentioned, Adam, there's lots of HOAs out there that have, neighborhoods and, different parcels and different, commercial parcels that may have different voting rights. So don't just assume that how it was done under developer control is the way. Again, thinking about, you're setting the tone for the rest of the time. Measure twice, cut once, I like to say with my boards. Let's get it done right. Let's spend the money up front with the attorney. And let's have a conversation. Let's look at the documents and make sure we get it right. And then you set the stage, for the next 10 years. So.
Yeah, that's what Jim's telling the people outside his windows too.
Yeah.
Measure twice.
Let me know if you need help, Jim.
Yeah. But yeah, it's absolutely correct. And yeah, if we can get you off on the right track that first election, that would be great, because we hear as council all the time. I'm sure you guys hear it as managers as well with new communities. When you look at their governing documents and you say, this is the way you need to do it. And they say, well, we've always done it this way. That's not how we've always done it. And yeah, exactly. I'm sure we've all heard it a million times. Like, well, I understand that's the way you've always done it. That is not a legal rack to hang your hat on.
It's
in
like
court.
my teenage kids telling me, well, Mom, that's all my friends are doing it. That doesn't make it right.
Exactly. So from a timing standpoint, it's going to be different for condominiums and HOAs. There's a more staggered approach to condominiums, where it's 3 years after 50% of units are sold to owners in a community that will ultimately be operated by the association. And then 3 months after 90% is sold. And for HOAs, it's 3 months after 90% of the lots are sold as well. There are additional timing provisions in both condominiums and HOAs. But what is important here to point out as well is that for HOAs in particular, there were timing changes that were added I believe in 2007 in the state of Florida, where prior to that, there wasn't a hard and fast deadline for communities to turn over in the same way that we have today. And one of the misnomers that communities have when they're wanting turnover to occur, and it has not yet, is that they look to the statute that is in effect as of today, 2020. And this is a very nuanced association law issue, but there is actually a constitutional law issue that comes into play here. Because, you may have heard of the unconstitutional impairment of existing contract rights. That's a mouthful, but essentially it says that if there is a contract that's been entered into between two parties where their rights have vested on either side, that the government can't come in and change the laws to impact those contractual rights that have already been vested. And in community associations, the declaration or the covenant and restrictions in your community is a very unique document that not only is a real estate type, real property type document with restrictions on how you use land, but is actually considered a contract between the declarant, the association, and the purchasers of the community. And so if there is a provision in your governing documents that the developer has written from the very beginning, that the law is going to apply as it was written when that declaration was originally recorded and created, you're going to have to go back to the statutory provisions in, let's say, 2006 and 2005 to see whether or not you have those statutory rights that you think you have under today's statute applicable to your community. The exception to that is when there is what's referred to as Kaufman language in your governing documents, and that refers to a case. And essentially, all that it is a phrase that says this declaration or this community is governed by Florida statutes or Chapter 720 or Chapter 718 as it may be amended from time to time. And it's that second phrase that's critically important, as it may be amended from time to time. And what that case law holds is if you have that particular language in your governing documents, it's deemed to automatically incorporate any legislative changes over the course of time into your the contract that you have governing your community, the declaration, the covenants or restrictions. And it gets more complicated than that. You can have Kaufman language that only applies to certain provisions in your declaration and in your community, which is, again, why you need experts to help you out with these things, because it's not always a clear question or a clear answer to give when you say, when is turnover supposed to occur? You might need to go through a constitutional law analysis to be able to answer that question.
And on that note, Adam, talking about a declaration, we did have a question. It says, can the developer make changes to the declaration without approval of the membership?
The quick answer is yes. And it depends on how the declaration was originally drafted when it was recorded. But developers do have the right to retain that legal authority prior to turnover. But it has to be in the governing documents. So there are, and that's a developer attorney issue to address. That's before it gets to us. But if for some reason the developers attorneys, maybe they're new to the industry, they don't provide that flexibility for their developer client, and they just include the normal amendment provisions in that declaration, then you're going to be governed by the same membership approval requirements that the association would have following turnover. But the vast, vast majority of the time, I would say upwards of 90% of the time, the developer will retain the ability to approve those amendments without membership approval prior to turnover. However, There's always a however, right? There's always a but for attorneys. No jokes about that, though. This is one of those situations where the developer amendments that are adopted prior to turnover are governed by a standard of reasonableness, whereas an amendment to the declaration by the members can actually have an element of unreasonability, if I can make that a phrase. So long as it's approved by the membership, so long as it's not wholly arbitrary. But for developers, they're restricted in it being reasonable for the community. It has to be in the association's interests, can't be unreasonable, and it can't change the nature of the community itself. And that's something that Jim was alluding to earlier in that, whether to intervene when there's going to be a sale. And when there's going to be an amendment, that's something that you can look to. And if you're a ways out from turnover, that may be something that you need to address on a membership level to challenge those potentially wrongful amendments. But for the most part, what we see, particularly for those communities that we're involved with as association counsel, we're looking to assist the developer in writing rules and amendments and changes to the declaration that benefit the community. But for the most part, they can. Okay, so corporate matters, moving on, the new directors. So this is I'll go over this very briefly as well. When you are elected as directors to the board, that is a different position than an officer of the association. And that's something that is confused oftentimes in general association law, where directors simply sit on the board. They don't have any individual authority other than to vote as a member of the board. And the board of directors is a collective governing body that makes decisions, typically by majority vote, on how to proceed with business of the association. Whereas officers, the president, vice president, secretary, and treasurer, are individuals that carry out those decisions made by the association. And so after you have your turnover election, you're going to have what's referred to as a organizational board meeting that happens typically immediately following that election. And that's when the newly elected directors vote among themselves to appoint a president, a VP, a secretary, and a treasurer. Establishing committees. So this is something where, again, we see this aside from the turnover committee, which is listed there as well. One of the first things that new turnover communities want to address are setting up the ARC, the Architectural Review Committee, or the Fining Committee is a very popular thing that you want to have set up. We would tend to agree. Those are good things to, if you haven't established those, it's a good idea to identify volunteers within your community and legally, appropriately establish those committees pursuant to the requirements of your governing documents. But one of the things that we very often see in setting up committees is that they just kind of accidentally coalesce into this group of folks that maybe designate themselves as the Architectural Review Committee or the Rules Committee. And really from a corporate law standpoint, from an organizational standpoint, and from a liability risk management standpoint for the association, you want to have defined limits of authority and grants of authority for these committees in written resolutions that designate who they are, who the members are, what they can and cannot do. So architectural review committees, you definitely want to be looking for volunteers. Fining and suspension committees, I will say probably more than any other issue. And that's saying something. More than any other issue, I almost guarantee every time we get a new client that hasn't had representation before, they're doing something wrong with their fining and suspension procedures. And for whatever reason, that it's a little bit of a convoluted process, but it's a little bit more nuanced than people typically understand for the very beginning. You have to have separate members that are appointed to the fining committee that aren't on the board, that aren't in the household of the directors. And if you don't have that committee, you cannot levy fines. Let me say that again. If you don't have a fining committee, meaning you can't identify willing members to serve on that committee, you cannot use fining as an enforcement tool in your community. So that's something to be aware of. Finance and Governing Document Committee, again, if you have people that are willing to participate in these committees and have useful skills to apply, then those make sense to adopt. The caveat to that is, and for all of these, is that you still want committees to be a benefit to your board. The board appoints, in almost every situation, the board will be appointing those committees, and those committee members will serve at the pleasure of the board of directors. So oftentimes we'll get a kind of reverse scenario where there are committees or boards that feel beholden to the committees that they've established, where the finance committee will say, these are our recommendations and you have to do what we're saying based upon our recommendations. And that's not the case. It's the other way around. This is purely for recommendations. So if you get to the point where your committees are actually causing more headache for you than help, you can usually disband them. And that's something that needs to be on the table and understood when you're having those interactions with your committees. And the other neighborhood, go ahead, Fiona.
I'm just going to add in there. I definitely see that, on our end, when we bring on a new association, sometimes there's hard feelings, right, between the committees and the board. And it's very unfortunate because everyone's volunteering their time. So, our guidance is always to have a very clear charter for each committee. So it's clearly understood, right, what the committee has been established for and clear objectives for that committee. And then at the board meetings, when the committees give their reports, really have a good line of communication back and forth, because it's unfortunate to see a committee go out and put all of this effort in, and then they're all excited and they come back and they present to the board, and the board doesn't do anything with it, or the board's disappointed and says that's not what we wanted. So being able to have clear communication from what everyone's looking for and expectation management, really, I think, is very important when it comes to committees.
It's huge. And I'd be remiss not to bring this up as well. It's not listed on here, but the most important one to have that charter for and a clear understanding is the security committee. We don't see that as much anymore. But if you remember a few years back with Trayvon Martin trial and tragedy that we had in the Central Florida area, that is a clear example of a neighborhood security patrol that didn't have any type of understanding of what they should or should not be doing, aside from any criminality that was alleged in that situation. But that aside, if you say bring 5 people into a room and say you're on the security committee, and then you just ask them, well, what does the security committee do? You're going to get 5 different answers. Yeah. And that's an issue that you want to avoid from a liability perspective for the association.
Absolutely. We had a question come in, Adam, about the fining committee. It says, does the fining committee have to be established prior to the first time the board wants to fine someone, or can it be established whenever it is needed?
It's an interesting question. There isn't any case law on that. But just, off the cuff, I do not think that you need to have the fining committee established the members established per se, so long as the fining committee has been appropriately appointed by the time you're going to have that hearing, that what's commonly referred to as the due process hearing, on whether or not a fine levied by the board is going to be approved. And just very quickly, the whole fining process in a nutshell is, after you do your demand letters and everything in the beginning and people haven't fixed the violation, then the board notices a regular 48-hour posted board meeting and votes on whether or not to propose a fine, levy a fine under the statutory guidelines for that violation. And then after the board votes to levy that fine of $100 a day up to $1,000 in the aggregate for a continuing violation, you send a 14-day, at least a 14-day notice to that violator that they have the ability to appear in front of the fining committee to essentially argue their case of why they should or should not have that fine implemented against them. And so technically from a timing standpoint, if the board only needs 48 hours to post notice and appoint a member to the fining committee, you could do that within that 14-day period. But all other things being equal, I'd prefer to see that lined up before you start sending out those fines, because the last thing that you want to happen is to send out all these proposed fines and these notices of hearing and then not be able to appoint that fining committee, and you've hurt the association's credibility at that point. And just another aside for new boards, your credibility, particularly when it comes to covenant enforcement and collections, is paramount. You cannot make threats that you are not willing to go forward with, because once you don't, everyone, nobody's going to take them seriously moving forward. So you're either going to enforce it or you're not, and either one is going to perpetuate throughout the community. Okay, so just more corporate issues. You need to confirm that you have good corporate status with the Secretary of State. That's you can get a letter of or certificate of good standing from the Secretary of State. And again, this is one of those situations where you're going to be relying upon Castle to help you out in these managerial aspects, because this is something that they do as a matter of course. And also why, please do not be self-managed as a community association, really ever, but particularly at turnover. That would be a thoroughly imprudent course of action. But just administratively, you need to confirm good corporate status, ensure that you have the proper corporate address registered with the state, change the registered agent if needed. So it might be with a developer, and the registered agent is the designated individual or entity that will receive legal documents addressed to the association. So it's critically important that you have a person or an entity that you can trust in that position. And then banking in the post office. People oftentimes leave this off of their checklist, but contact the bank and the post office to confirm that you have access to those accounts and that the proper mailing address is on file, so that if there is something coming in to the association, it's not going inadvertently to the previous developer, or certainly that you don't have access to the association's funds. Review of the official records. So the developer is required to, by turnover, provide transfer all of these records and physical property to the association, with the exception of turnover audits and financial statements. Those can be provided within 90 days following turnover. But for everything else, all of these items are supposed to be transferred by statute, and a receipt is supposed to be signed. So you sign a receipt at turnover acknowledging that these records have been transferred, but you still need to go through and verify. Clearly you're not going to do this at the turnover meeting. Ideally, this is something where the transition committee or the turnover committee would have been looking into ahead of time so they feel more comfortable at that turnover process. But on here, the easy things, governing documents, minute books, financial records, all of those are things that you would anticipate being transferred to the association. But construction plans, warranty information, build out plans, property inspection reports, those are critically important as well and aren't necessarily thought of by new turnover boards because you think of that as being a developer document. And while the developer may be involved with that document, it's important for you to know how your community is constructed and how it was intended to be constructed, because that can come into play if there are going to be potential claims for the construction of the community down the line as well. There's actually also implications for insurance reconstruction as well, because there are certain obligations for the association to reconstruct after a casualty event to what was originally built by the developer or designed by the developer. So those as-built plans come in handy in case, I'm going a little bit further down the rabbit hole, but if you're in a condominium situation and you have a casualty event and someone had installed, Canadian hardwood ceilings in their unit, and they want the association to replace that after a water intrusion event, they're not going to be entitled to that. They're going to be entitled to the drywall that was originally installed by the developer, and you want to be able to have some type of document to point to that to help support your argument as the association.
And Adam, what if the developer says, we don't have it, or something along those lines, especially for our person on here who says, the developers changed prior to closing?
Yeah, and the simple reality is that is sometimes the case. Sometimes they don't have it. And again, I'll bring up the financial crisis as well. When there were foreclosures and there were these acquisitions were happening in bankruptcy court, as you might imagine, there wasn't the neatest of transfer of records when developers and even management companies were going belly up. So depending on what the documents are, you need to address it on a case-by-case basis. But if they don't have it, they don't have it. If they don't have it because they aren't looking hard enough, that's another issue. And then there are certainly arguments to be made that if it's a document that the association needs to rely upon, that the developer not having that record shouldn't be used from an equitable standpoint to harm the association in any argument that they may have against the developer in future disputes.
And then we had another question come in regarding records. It says, who in the association should receive the documents that are the official records?
Yeah, so the statute actually doesn't specify individuals. It just says to the association. And the irony is, and I'm sure you guys have come across this quite a bit, Fiona, if there is consistency in management, it is more of a informal or conceptual transfer of the records. If the management company is the same and remains the custodian of records for the association through turnover. However, it is still something where you want to have the developer make any transition to the management company, typically, if you're going to have that management company moving forward. But it's also something where if the board of directors is insistent upon it, that's something where, or you're changing management companies, that you can look to have those records delivered directly to an on-site office if you have it. What I would not typically recommend is to have those official records put in the foyer of the secretary's house, because there's a whole variety of situations that come up, whether that secretary gets voted off or recalled or moved, or, that there are just a lot of, it's a ball of wax that you don't want to have to deal with. But for the most part, and correct me if you have a different experience, Fiona, but we see the management companies either just maintaining custody of those official records as the association's manager, or receiving them from the developer.
Yeah, it's typically both in that in a lot of cases we have a lot of them already, but we still document at the turnover meeting, this is what we have, this is what we're receiving. And for the most part, they're coming in electronically. So typically what we do from a Castle Group standpoint is we actually put everything on a zip drive and give a copy at the turnover meeting, to whoever the new board is, so that they can see it sort of and touch it themselves and see it that it's been received.
Yeah, and again, with the inventory of all records and putting them online, it would be great to do that. It will never be easier to organize or govern your official records than at turnover. It's only going to get more burdensome as time moves on. Verifying property ownership. This is, you're needing to see what property the association owns. Obtain certified copies of the recorded plats if you don't have them already. And the plats are, essentially is a map of the real property that is governed by the declaration and your community. Identify and inventory all the real property, if any, which is to be owned by the association, and confirm that it has been legally transferred. We see this a lot where there are tracts of land years after turnover has occurred that remains legally in the name of the developing entity rather than it being transferred to the association. And it's not a matter of nefariousness. The developer doesn't want to have that land in their name typically anyway. It's just an oversight. So, all you have to do is do it once, again, setting yourself up for success for the rest of your operation post turnover. Have a good map made, pay a professional to go through, have a title report, confirm that you have that property, and identify utility easements and public dedications, whether you have roads that are dedicated to the public. Determine the maintenance responsibilities for those. Just because an easement or a tract is dedicated for use to the public does not mean that the maintenance responsibility is transferred as well. So you need to, those are two separate issues that need to be reviewed, and determine whether there are shared maintenance and or use agreements for property within or surrounding the community. And this often comes up in the context of master plan communities, or where there are multiple communities close by that have been developed, where sometimes you will have a clubhouse that is shared between different communities, and you want to know what your obligations are for those at the outset as well. Okay, so this is review maintenance and insurance obligations. From a maintenance standpoint, I'm going to have, I think Nagar is going to jump in here on the next slide. But from a maintenance side of things, this is something where Nagar and I and her partner, Phil, give an hour class on this alone, or 2-hour class on this subject alone. So again, we're going to jam it in here to three slides. But you have to look at maintenance and repair obligations as distinct from your insurance obligations. And that is whether or not you're going to be repairing based upon regular maintenance obligations or under insurance obligations depends on how the damage occurred. But from a regular wear and tear standpoint, from a maintenance standpoint, condominium and townhome HOAs with attached dwellings, it's critically important for you to understand what your obligations are as an association and what the individual owner's obligations are for those attached dwellings. Because if you have a roof that goes across 8 different townhome units, you need to know who's responsible for taking care of those. And frankly, hopefully it's going to be the association. For townhome HOAs, one of the problems that we see oftentimes is that the maintenance and repair obligations aren't adequately transferred to the association for the exterior walls and roofs of those townhomes. And that can really cause a lot of problems for townhome communities, because people will assume that the association is responsible for maintaining and repairing the roof, and that may not actually be the case. For condominium associations, this is more governed by statute. For general common elements, you're thinking of clubhouse, the general common element, hallways or pool decks. Those have to be maintained by the association by law. However, if the declaration designates a common element as a limited common element, which is a common element that is restricted for use by only an individual unit owner or a group of owners, if those are designated as limited common elements, then the declaration can also transfer maintenance responsibility to the owners that have those exclusive use rights. So you need to identify those as well, but don't just assume that because it's a limited common element that maintenance obligation also transfers to those individual unit owners. That's a two-part process to identify it as a limited common element and then transfer that association obligation to maintain to that individual unit owner. And then for units within a condominium, it's typically going to be the owner's responsibility. But there are exceptions to that. You can still provide in your governing documents that the association is responsible for maintaining or repairing certain portions of the condominium property that lie within the legal boundaries of that condominium unit. Okay, and so Nagar, do you want to just kind of go over the insurance obligations here for 718?
Yeah, thanks, Adam. Okay, so as Adam was saying, I work with a lot of associations. I also work with a lot of developers. So back when Adam was talking about sometimes they get the new, turnover committee will say, should we just get rid of all of our current vendors? And as somebody that works with the developers, I would agree with what Adam said. You should at least interview them, because a lot of times what happens is property managers that are well known and have a lot of experience will end up going to work for the developers as like an in-house HOA manager. So there's a couple things I wanted to talk about here, especially from my perspective of working both with the developers and then with the boards after turnover. One, let's start with condo associations. It's pretty easy because the state's going to dictate, at least in Florida, those items that must be covered on the association's property policy and which policies they must buy. There are some elective coverages and some elective policies that we highly recommend to our boards that they purchase, and that's why it's important you work with an agent that specializes in condos and HOAs, because we're going to be able to guide you. So condo associations, they're not building quite as many of those these days still in Central Florida, way more popular in South Florida, but the policy you buy is going to effectively, to make this easy, cover from the shell to the outside. So think everything behind the bare, unfinished drywall is going to be on the association's policy, which is paid by unit owners via your dues. That's going to be drywall, electrical, plumbing, insulation, and to the outside, stucco, siding, a hardy board, windows, roofing. The key here is it's going to cover those items in an insurable event, okay? And that's the policy for the association. Unit owners are going to be responsible to purchase what's known as an HO6 policy. That HO6 policy is designed to pick up the responsibility for everything that the association's policy does not cover. And those items are listed on the slide. So as you can see, floor, wall, and ceiling coverings. If you could see this room right now, I've got wallpaper on my walls. If I lived in a condo, that would be on my HO6 policy. Electrical fixtures, built-in cabinets, countertops will all fall on your HO6 policy. What I would tell you as somebody that is sitting on the transition board, the turnover board, there are two big problems I find as it relates to condo association policies. Okay. One has to do with the property limits, and they fall into two buckets. One, they are either way underinsured on the values. And you want to know why? Let's think about it. The developer is the one that binds the property policy. Like, I work with a lot of large developers, ones that you guys have probably bought from. The cost to them to build the shell of the building is a lot less. So when they're getting the policy through me as a developer and they're giving me these limits, it's their cost to rebuild, right? So if they're at a loss, they're going to go rebuild it, and they can build it so long as they're still there, right? So it either is way undervalued. So one of the biggest recommendations I would have is get an appraisal. The developers aren't going to pay for an appraisal, right? They're like, what do I need an appraisal for? I'm a builder, and this is how much it cost me to build it, right? So it's either way underinsured, right? And I actually had this happen once where a condo association didn't get an appraisal, right? And this was awful. A fire happened. Now, per law, you're supposed to have an appraisal for the 718 statute every 3 years. And not every board does it. It is what it is. So they had a fire, and the limits were way less. They were not sufficient to build it back, because when you're bored and you need to go get your building reconstructed, it's going to cost a lot more than what the developer could have done it for. Okay, because the developer doesn't add in their markup and their margin. Or, and here's the other one, and boy, I feel bad when I see this, especially if I'm meeting the board way late. The values are way too much. And why they're way too much sometimes is the developer, erroneously, if they're not working with an agent that specializes in this stuff, the agent insured the structures to contemplate for the interior build out. So there's a whole section that the association is not even insuring because it should be insured by the unit owners, right? So my point is, if you're a condo association and it's the turnover process, you really should get an appraisal done, okay? Now, if you're a townhome unit, are you going to that next?
Yeah.
Okay, all right. I try to get my developers to do this. I beg them to do this. If you're a townhome HOA in the state of Florida, please be sure you look at the legal name or your docs. And the reason why is townhomes can fall into one of two buckets, as Adam will tell you. You can either be an HOA, right? So you can be named Sawgrass Point Homeowners Association, right? Or you could be Sawgrass Point Condominium Association. It's the same townhome community, but one's a condo and one's a townhome. I've seen it happen. Back when Syntex was building, they had to have one association that looks exactly the same as an association down the street, but one was a condo and one was a HOA. I don't know why. I don't know why they do it, but they do it. So here's the thing. I've had discussions with all the major builders as their agent, and I beg them. I'm like, please, if you're constructing a townhome community, fine, call it an HOA if you want, but please design the docs so that the association is responsible for taking out the insurance on the shell of the building. Please don't leave it up to the unit owners. And you know what they say to me? They say to me, oh, well, if we take it out, the dues are going to look more expensive. So no, we're not going to do it that way. Wait.
I'm shocked, Nagar.
Oh my God, they want to be competitive, right? So they're like, no, we're going to make the unit owners buy the insurance. But here's the problem. From state to state, laws change. And unit owners, particularly if you're in Central Florida, or Florida for that matter, there's a lot of snowbirds here, right? And a lot of snowbirds that may be buying cash. So your mind would be blown how many unit owners that live in these townhomes, and some very fancy schmancy townhomes, just assume that their shell of their building is covered by the HOA, when in fact it's not. So here's what can happen. I had an association where I didn't come until after the fact. It was a townhome building, same shared roof lines, shared walls. There was a fire that occurred. Guess what happened? Took out the entire building. Well, Only half the unit owners carried insurance. They could not build the building back because per the docs, you have to rebuild the building with the same number of units. Half the unit owners in that building thought the association covered them, right? And they didn't have mortgages. That was a nightmare. It sat burnt down for the longest period of time because that was also during the recession. So that was one nightmare that actually happened. And another one is, this just happened. I helped turn a community over that was a townhome HOA, and we helped, it was an entire process, a long process, but we were able to get enough votes in the community to where we converted them to a master townhome association. Guess what happened 2 years later? Hail damage. They are now, the claim just settled, getting all new roofs in the community. It's like a $7 million settlement. Could you imagine living in that community and not having a master property policy and having to deal with 150 different claims? I know you've seen those communities because you drive by and everyone has a different roof color. Yeah, you don't want that. So for those that are on a turnover committee and you've checked the name of your association and your townhome, what I would say is, and Adam, chime in here, try to get the docs amended so that you have the authority to convert by a mere board vote. Because if it's left up to the whole community, it's almost impossible. So Adam, I'm glad I have you on the call. When would these homeowners be able to do that? Do they have any benefit of doing it before official turnover?
Yeah, and this is actually a perfect issue to do prior to turnover, because if it requires a membership vote to amend your governing documents, for the same reason that you want the board to be able to elect to provide this master policy, you don't want to be beholden to the membership to amend that.
No.
I still think that we can convince them the prudence of doing so, and hopefully the membership would ultimately vote to amend those governing documents. But Nagar is absolutely correct. And we have seen some of the same disasters happen and some of the same near misses happen where communities were able to convert. Nagar's helped me actually convert a couple of our clients in that respect. But this is one of the few times that you will hear an attorney say this. I guarantee you, if you are a townhome HOA that doesn't have a master policy, there is a significant number of unit owners in your community that don't have the proper insurance. They will have an HO6 policy because whoever their agent is giving them that policy that only insures the interior of their building, when in actuality, they need to be insured like a detached single-family home that includes the structural aspects all the way up to the roof as well. So
and guess what? Yeah. And this is the biggest kicker. The price is essentially the same to the individual unit owner. Right? So that's the crazy part. So at least do yourselves a favor as a community and allow the association to take the responsibility and insure the shell, right? Because then you know for sure everybody has coverage. It's easier for claims processing, because, and this is where it gets weird, a lot of times I'll see in the docs that the association and the townhome HOAs are responsible to replace the roof. But they're
not responsible to insure it. Yeah.
But they're not responsible to insure it.
Exactly.
So it's like, all right. But my point is, the reason why I say it's materially pretty much the same cost is because when you convert or have a master property policy, then you as a unit owner, I'm going to put this in layman terms, only have to buy the less expensive, cheaper policy that covers the interior. However, if the association is not responsible to insure the shell, then you as the unit owner have to insure the whole shebang. So the cost is not materially any different. You're just transferring the responsibility to the other party to insure the shell. I hope that makes sense.
It makes perfect sense. Thank you so much, Nagar.
And you're welcome.
And I'm going to try to skip through these at a little bit faster clip so we can get through everything and hopefully have some time for some Q&A. But easement and plat notes, again, identify and inventory all these easements. That's going to be separate and sometimes a little bit more difficult than determining transfer of title to the common areas. because oftentimes you'll see, the perimeter wall easements, that's not actually title to land that would be in the association's name. But it would allow the association to enter upon an individual owner's lot for the purpose of maintaining or replacing a perimeter wall or certain landscaping, seeing where your sidewalks are located in your community and who has the maintenance responsibility for those. That can be a big an issue for larger communities where the sidewalks kind of go back and forth sometimes between being on the common area road tract and then onto the individual owner lot tracks or individual owner lots. And just making sure you know what those maintenance responsibilities are. The other thing that I want to point out here on the plat is that there are restrictions and some limitations that are included in the notes section of the plat, which are in impossibly small font, to the point where you have to have a magnifying glass sometimes to be able to make out the words. But those can supplement your declaration. So if something is not addressed specifically in your declaration, sometimes the plat will have maintenance obligations and use restrictions as well. The other thing that you want to do is review existing contracts. Know when your expiration dates are and your renewal dates are, particularly for multi-year contracts. The worst thing is when, we have a client come to us and say, hey, this, contract renewed 3 months ago, can you please review it and let us know if it's good for us or not? It's like, well, you're kind of putting you put the cart before the horse there. We can't do much about it now. It's now renewed for another 5 years. So at the outset, review those things, make a simple spreadsheet so that you know what's coming and how each contract may be terminated, or so that you can elect not to have an automatic renewal if appropriate. And for 718 condominiums, also know that some long-term contracts can be terminated by the members immediately following turnover, regardless of what's in the contract. And so that's a statutory provision. However, you can only take advantage of that at the first membership meeting following turnover. So that's why it's critically important for the transition committee and or the newly elected board to review those contracts, because you don't want to inadvertently miss that opportunity by holding a membership meeting to vote on, whatever you may be wanting to vote on without putting that on the agenda as well. And again, just determine if those contracts are fair and beneficial for your community from a post-turnover standpoint. You also want to have, obviously, a review and analysis of the governing documents. I say obviously because I'm the attorney on the call. This is what I do day in and day out, but self-serving comments notwithstanding, it is important for you guys to have a working knowledge of your governing documents, and have your legal counsel review it to see whether or not amendments are appropriate. And again, ideally, you're doing this as a part of the transition committee before turnover, with the blessing of the developer controlled board. Because the other thing that you don't want to do necessarily is spend a lot of time and effort drafting these amendments only to have the developer say, no thanks, we're not going to implement these. So it is a more collaborative approach where you have to have a conversation. But, listed down here just really quickly, insurance and maintenance provisions that Nagar just went over, critically important to review. Alternative dispute requirements, to the extent a developer is willing to amend those ahead of time, great. If not, that's something that you may need to address following turnover. Those can really come up to bite associations if you're not careful. Covenant enforcement remedies and costs. This is an extremely popular amendment. It's something where you can usually get support fairly quickly and robustly in your community. And it essentially says that if someone violates the governing documents and the association has to hire me to help enforce it and pay our office to do the covenant enforcement, it's the owner that's violating the governing documents that should be having to pay the association's legal fees. But you cannot do that unless you have that in your governing documents, at least for pre-suit costs. And everybody says, well, isn't that provided in statute? There are prevailing party attorney's fees that are provided in both 718 and 720, but prevailing party attorney's fees involves going through a dispute and having a judicially determined prevailing party in that dispute. And what we're interested in, because the vast majority of time, you're not going to be hopefully going through the end of a lawsuit or dispute resolution. You want to be able to collect those costs from the violating owners prior to a lawsuit going through to completion. Assessment lien priority. This is something where, again, it gets kind of into inside baseball from a collection standpoint, but you want to be able to have the association's financial ability to collect on delinquent assessments as strong as possible in comparison to other lien holders. There's not a whole lot that we can do on first mortgages that are on the property, which typically take priority over the association's assessment liens. At least up to the safe harbor amount, but you want to make sure that you at least have safe harbor amount, which is the lesser of 12 months assessment or 1% of the mortgage currently burdening the property. But if your governing documents say that first mortgages that foreclose on the property aren't responsible for any delinquent assessments upon taking title, then you're not even entitled to safe harbor amounts. And that's an easy fix for the community. And in terms of use restrictions, you can adjust those to the way you want your community to be governed. And when I say use restrictions, that's typically, it's in like Article 8 or 9 of the governing documents or of the declaration. And it's what we refer to as the dirt restrictions. You can't have a fence here. You can't use the lots for commercial purposes. No 50-foot Elvis statues in the front lawn. There are a bunch of things where you can control those use restrictions. But in terms of rulemaking authority, particularly for HOAs, you want to see whether or not the board has rulemaking authority over individual parcels and lots within the community, because a fair amount of the time, HOAs will only have rulemaking authority by the board over the common areas of the association, meaning that you cannot adopt rules and regulations governing those individual lots. And that would be something that would need to go through the membership approval. So check, you can add that authority if you don't have it, but that is something that you want to look for.
Before you move on off that slide, Adam, I wanted to just make one comment sort of thematically, because as a litigation attorney, I'm often dealing with governing documents that communities are stuck with or haven't spent a lot of time thinking about. And thematically, understand the governing documents are created by a for-profit company, for better or worse, with the motivation to build what they believe to be a quality product that they want to sell, and then they want to move on and limit their liability over the long term. So they're looking at it from a perspective of efficiency and profitability, and that's not an insidious or a wrongful intent perspective. It's a good perspective if you're focusing solely on business. As members and board members, your perspective is much longer term, and you're focused on governance, sustainability, durability. So when you look at the bullet points in the slide that Adam has presented, what you want to think about is, as we're operating this community over decades and maintaining and repairing and, trying to keep the community in the best condition possible, what are the things that we want to take a hard look at and change? And at turnover, that's your real opportunity, and probably, depending on the exact timing of things, your best opportunity in terms of united we stand, divided we fall, community cohesion and common purpose. And so it's a great time to take a critical look. And as a litigator, I'm concerned when I first meet with potential clients, and Adam and I are looking at a community, what are your rights, obligations, and powers under the governing documents, in terms of, and a lot of times what I'm dealing with are construction defects or property damage concerns, but what can the board do on behalf of the membership? And so it covers a lot of the things that Adam has already talked about, insurance and maintenance provisions, but also what we call, and I do a lot of developer work, so this is jargon among lawyers, which we call poison pill provisions. And I've drafted them for developers, and I've done away with them for turned over communities. And really, when you look at the developer's perspective, what are we trying to do? We're trying to build a quality product that we sell and then we let go of and we turn over to the buyers to operate long term. They want to create relatively high hurdles for there to be litigation or disputes between purchasers and the development regime. And again, that's just the reality of the business world that we exist in. But at turnover, you have an opportunity to look at some of those things. And a lot of times they're risk management purposes. They actually overlap with what Nagar was talking about from a developer and an insurance perspective. They are high hurdles from a vote to approve litigation, allowing the developer to have seats on the board, maybe for a long time after turnover, or otherwise the developer is entitled to notice or an opportunity to participate in dispute resolution procedures as a precondition to different types of remedies the community may seek, whether it's over financial mismanagement issues, whether it's over property condition issues. So again, I'm mentioning some thematic things and a little bit of specifics based on my experience as a litigator. The take-home point of this is that turnover is that opportunity to take a look at these issues and to team up with your management group and your general counsel lawyers to tackle some of these issues. And you'll never be more educated, hopefully, than at the time of turnover. And if you take a moment to think about what the issues are that the community will be tackling immediately upon turnover, 1 year out, 5 years out, 10 years out, 20 and 30 years out, and it doesn't, and you've got advisors on board with your management team and your general counsel lawyers, your insurance professionals and others that can help you go through this process quickly, efficiently, and at a relatively low cost, so that someday, God forbid, you have to deal with a lawyer like me, you're in the best possible position to act swiftly and efficiently for your community and get a good outcome. And we'll talk very briefly about that later on.
Thanks so much, Jim. That's very well put. Go ahead, Fiona.
I was going to say, one of the questions that came in around professionals is asking, why do we need professional engineers during the transition? And what type of engineer do we need?
Jim, you want to take that?
Sure. And this is something we would have talked about a little bit later, but turnover is really your opportunity. And there's the old proverb, in crisis, there is opportunity. In turnover, there is opportunity. And when I talk to boards, I say it's really, turnover is your opportunity to learn and to act if you have to. So having architects and engineers participate in the turnover process, and it doesn't have to be at the moment of turnover. It's not a blink of an eye or a snap of the fingers. Oftentimes, and sometimes it's required, you're going to receive a turnover report from an architect or an engineer from the developer. As a litigation and a construction lawyer, I caution people, boards, to almost disregard that and seek a second opinion. It's like if you got a really good diagnosis, but you thought that you had an illness, and it's the opposite of the terminal second opinion, it's the rosy second opinion. I'm hearing a lot about problems that turned over communities are facing. I've got an engineer report that the developer purchased that says things are really good, but the engineer really didn't do any testing, didn't walk through. I don't really know what the relationship between the developer and the engineer is. So, how good is this information I'm receiving? And so at the turnover time, and really it's turnover in the year after, where we typically recommend that the board take the opportunity to educate itself about the physical condition of the community, and ultimately what the maintenance requirements are. Because if you have exotic materials, if you have really unique types of buildings or systems, if you're a mixed use community, the things you need to do to maintain and repair over 30 years are going to be different than a simple townhome community. So you get an architect or an engineer involved to do a fairly thorough property condition assessment for the board, for the membership, so that early in the regime of the turned over community, you have an idea of what your issues are and how to maintain your community. In the best case, you have an engineer or an architect that says the community is in great shape. These are the things you want to keep an eye out for. And like Nagar and Adam and Fiona have been talking about, at turnover, you're looking to establish relationships that hopefully will serve the community for years and decades to come. If you get a good architect or engineer involved, when you're doing reserve replacements of roofs or sidings or windows, regardless of whether you're ever in litigation, you have a trusted professional who you can rely on. And so getting them involved fairly early after turnover, giving you a snapshot in time based on a thorough analysis of the condition of the community and what you need to do to maintain it, will give you, if nothing else, peace of mind and a roadmap for the future. It's money well spent. In the worst case scenario, they may find that you have problems, in which case you've identified these concerns early enough to take action, either by going back to the developer and having a productive dialogue with them about what the architect and engineer working exclusively for the turned over board and membership has found, and giving the developer an opportunity to step in and take responsibility and work collaboratively to address an issue. And if that's not a possibility for whatever reason, then the engineer or architect can be a consultant for you in the litigation process. And Florida requires a statutory notice period, which is a more formal invitation, working with that architect and engineer to go back to the developer and other potentially responsible parties, their designers, their subcontractors, material suppliers, manufacturers, and say, hey, we have a problem. It's no fault of ours. We're innocent purchasers and we're learning how to govern and operate our community. Our architect or engineer says these are things that need to be fixed. Developer, please help us. We approached you informally. Now we're doing it formally under the Florida law, Chapter 558, that requires us to send notice. And we've got our engineer here to help you. And if that doesn't bear fruit, then you may end up in a litigation posture. But that's why you want the architects and engineers involved early in the turnover lifespan. And then at years approximately 4, I usually tell communities, is a good time to have the architect or engineer take a second look, because a lot of construction defects are what we call latent, and the law in Florida recognizes a difference between latent and patent defects, or unknown and known, or concealed and obvious. So if conditions are concealed, even to a trained eye of an engineer, oftentimes 4 years later, while you're still within a time frame to act on your legal rights, the engineer can then document and observe those conditions. And if necessary, you can repeat the process I just described over again of going to the developer, asking for a collaborative assistance. If that doesn't work, you can escalate. And then again, we recommend that people do a more rigorous evaluation in years around 8 or 9, because in Florida, the law is that about basically 10 years after completion, it's what we call a period of ultimate repose. It is the ultimate cutoff of claims for property damage, construction defects arising from the original construction of the community. And Florida law is unresolved really about what completion means to absolutely trigger that 10-year period of time. And so we tell folks to avoid being in a situation where you're arguing about dates and your backs are against the wall. In about 8 or 9 years after you hear that the first COs were issued, certificates of occupancy, the first homes, first buildings are finished in a community, have an engineer come out and take a look. And again, it is not the end of the world if you don't get the turnover report in year 1 and you do it in year 4 and you're having a relationship with an engineer at that point. And then, 8 and 9, you don't have to worry about. And it's not the end of the world if years 1, years 4, you don't do it. And then 8 and 9, you do have an engineer finally come out and you identify issues. You're still within a time frame where you can take legal action if necessary. But this is a course about best practices. It's a course about, putting a team together early. And, communities oftentimes are reluctant to bring in outside professionals for concern about cost, concern about, the burden associated with it and what the motivations of the outside professionals are. And what do we do if these people tell us to take action? Everybody involved in this program and lots of other people in the state of Florida can help you build a really good team to serve your community. And the reality is the more you act early, you intervene early to establish good processes, best practices, the easier your community will be to govern, the easier it will be to maintain, and the more money ultimately you will save over decades and decades. And the practical consequence of that is no matter how long you intend to live in a community, whether it's 1 year or 50 years, 1 year or 50 years, you're going to be in a community that's well managed. It gets good legal counsel. It's well governed by its volunteer board. Its members are informed. They have property that is, well maintained and holding its value or appreciating. Whereas other communities throughout the state of Florida may be in disarray if they don't have the benefit of, this type of proactive education course and getting the tools to go out and act on it. So particularly for the folks that are participating, that are part of, transition committees or communities that are newly turned over or about to be turned over, the timing is excellent for you to act and really have a high level of confidence that you're in great shape and hitting the ground running. So that's the long-winded litigation attorney, trial lawyer answer to why architects and engineers are part of the turnover process. And if we can get lost in the weeds, we do entire 2-hour presentations just on that.
I know it's a lot. It's a lot to put into a short time frame, but we did have quite a few questions that came in. Adam, how are we doing on our slides? I want to make sure you get covered what you needed to cover, but
so why don't we do this? I'll just run through the last few slides and come back. I skipped to the last slide here when Jim was talking about this because it's such a critically important issue. I wasn't going to step in front of that train. But the, and I'll go a little bit further than Jim in terms of, why you do that. I really think there's a fiduciary obligation for new boards to have the physical condition of the property inspected by a independent professional because it has so many implications, good, bad, or indifferent for the community. And if you have a good, clean bill of health, great. If you don't, you can take action on it. Oops. Oh no. Let me scroll through here. I can recover quickly. Okay. Everybody see this okay?
Yep.
Okay. So let me run through these last ones real quick. Financial matters. So the developer turnover audit requirements are supposed to be provided within 90 days of turnover at the developer's expense, except that for HOAs, if it's a community that's created prior to 2008, it's not a developer obligation. So just be aware of that. Regardless, the association should obtain a turnover audit to determine whether or not the association has been funded properly, including any mandatory reserves that may have been required for the association during the pre-turnover control period. For condominiums, it's deficit funding is addressed a little bit differently between condominiums and HOAs. For condominiums, it's much less common because deficit funding is also tied with what's referred to as a budget guarantee. And a budget guarantee is a completely different concept than a promise to deficit fund. And the budget guarantee is essentially saying, while we're deficit funding, we promise your assessments in a condominium will not go over $200 a quarter or $200 a month or whatever the case may be. And as soon as the developer stops guaranteeing that maximum amount of assessments, then they're no longer able to deficit fund, and they have to pay their assessments on the units that they still own. For HOAs, the deficit funding and the budget guarantees are separated. They're not tied together. So for HOAs, almost all developers do deficit funding rather than paying their assessments on the lots that they own. But you still need to make sure that that's being done appropriately and properly, so that there isn't a inaccurate due to developer reflected in the turnover audit, which is fairly common. And we oftentimes find errors or disagreements in those types of reports. And also, again, critically important to address at turnover. Governmental agency review for their water management districts that will be incorporated, particularly in homeowner associations that have a lot of surface area. You need to make sure that those permits have been assigned to the association, making them the operating entity for the stormwater system. If there are any deficiencies in that stormwater system, you need to have those cured, obtain the copy of the permits that identify all those obligations that have been or will be imposed on the association. So you're thinking of, the retention ponds and those maintenance obligations, clearing, drainage tracks out. And obtain copies of maps and plans which identify the scope and the size of the stormwater system. You need to be aware how big of a burden you have on your hands. Finally, with the county and city level, obtain copies of the development phase of those committee meetings and those development orders. Because sometimes there are additional requirements on developers that date back prior to the incorporation of the association that may be the responsibility, the continuing responsibility of the developer and also of the association. So you want to make sure that eyes wide open what your obligations are going to be moving forward. And again, lastly, obtain copies of all governmental documents, ordinances, agreements that create and control the operation of community development districts, and identify the relationship between it and the association as to the ownership and operation of various elements of the community. And typically what we see is in master planned HOAs that are large communities, there will be roads or common area tracts that typically would be maintained by HOAs that are instead maintained by a community development district and is managed separate and apart from the association itself. So with that, I ran through that pretty quickly, and I think we
Yes,
can
you
get to the Q&A. Nobody accused me of not being able to fit something in.
There you go.
So what do we have, Fiona? We got a couple of minutes here.
Okay, so we've got a question. It says, does the 10-year period for remedy apply from the date of completion of a building or other physical property or from the date of turnover?
Maybe.
Yeah, exactly. Maybe, and then some. The law in Florida is very unresolved, and we have a conflict of authority from different appellate divisions and trial courts throughout the state. So there isn't really an answer. The statute, the way it's written, says it's the later for ultimate repose periods. The period begins to run upon the later of several dates, and that includes actual possession by the owner, which could mean the very last sale in a community. Some lawyers argue that might mean turnover, and then of course it's also tied to completion of the construction and design process. And the law, the actual law on the books is changing, frequently in this regard, and there are efforts to define this more clearly, but in reality that hasn't happened. And so what we tell communities is assume it's 10 from the earliest date that you can think of. So if you're in a phased development or a development of lots of buildings, that were existing before the community was ever turned over, figure out when the earliest buildings were finished, either by a final inspection or a certificate of occupancy, depending on what county you're in and how the permitting and inspection procedures are supervised, and then assume that you need to do something by that date. Most likely and almost for certain, it's going to be later than that, but not so much later that it's going to make sense to defer action any longer. So again, we try, when the law is uncertain, and it often is, even when the language of the law seems clear, reasonable lawyers disagree about what it means. In this circumstance, you have a number of triggering events for when the ultimate repose period is supposed to start. And there's a lot of disagreement and a lot of uncertainty about what those mean and how to evaluate it. So as a rule of thumb, we just say 10 years from the completion of the earliest building in the community and go from there.
Okay, and then there's two questions that are kind of the same, which is, well, what if your earliest building was more than 10 years? What would your guidance be? Is obviously check with your attorney, but it sounds like there's a lot of variables there.
Right. So in our communities, most of our communities, it would be lovely if every community that Adam and I ever saw, got to us early in the process where legal claims were fully intact and things are, early enough along that we can do sort of a diligent systemic investigation into the condition of the property. Most of the time, what we have are, communities of many buildings, hundreds of homes, whether it's a condominium or a townhome community. The reality is condominiums are easier because you're dealing with common elements and common ownership. And so arguably, as long as one unit in however many units there are in a condominium was completed less than 10 years, without regard to any of the other arguments, you're probably in pretty good shape. And I've actually litigated cases in Florida where a community of 101 condominiums, which was actually separately deeded single family residences, only one of them was within 10 years when we were retained and filed suit, and we were able to sustain that action. In an HOA environment, when you're dealing with Chapter 720, it's a little less clear, and you have to really look at the facts. Is it a phased development? Do you have one builder throughout? If you have one builder in a single phase and there's 100 townhomes and 80 of them are more than 10 years old, when you talk to your lawyers about taking legal action for property condition, I feel pretty good that we can make strong arguments that the whole community is going to be timely. It's always contested. It's always a less than perfect situation. It depends a lot on the advocacy that you get from your lawyers. And to some degree, the luck of the draw with the defendants involved, who their lawyers are, who the insurance companies are for those defendants that have duties to defend and indemnify for the property damage your community may be experiencing. So the long and the short of it is, it's a challenging thing to evaluate timeliness of claims. And the most important thing is, if you have concerns, talk to your legal team, bring it to the attention of your management team so that they can get you the resources, and we can make quick work of it. We're nothing, if Adam and I ever are confronted by an issue like this, we understand it can be the difference between millions and millions of dollars of consequence to a community. So we work very hard and very quickly to come up with a reliable solution and, to be as creative as possible. And because we do a fair amount of work on a contingency fee basis, if we're taking the risk that our legal conclusions, our analysis is right, we are taking risk with the client that if we're wrong, we're not going to recover our attorney's fees. And that allows for, an aligned interest with our client partners when we're evaluating risky claims.
Right.
We try to put clients in the best position possible to take action, even if it's not a smooth road.
Okay, and I think last question, I think this is coming from the association that we talked about earlier, that's a condo that has a new or a second developer, and they're saying, is there anything the association needs to be aware of with the new developer who will still be building and breaking ground on 5 new to be constructed buildings after turnover? Anything special they should watch out for, do you think?
There's lots, and I'm sure Jim and I can both speak on this. at length, and I'll try to not do so. But you need to be aware of what the reservations there are in the declaration for declarant rights and builder rights, because there might be a difference in how the association can control the building, the architectural aspects of those buildings going up. Developers are typically very good at keeping flexibility for their building operations and their sales operations. But it depends on what they have included in the declaration from the very beginning. So there are a lot of operational aspects from a general counsel's perspective that are dependent upon your declaration. And just rattling them off the list is, whether or not they're going to be responsible for paying the assessments on those condominium buildings, because they've already created them under the governing documents on what they are referred to as phantom units, meaning that from a legal perspective, all 5 buildings have, if there's 50 units within that building or 10 units within that building, whatever it's going to be, those units are technically already created units and need to be assessed, their assessments as part of the condominium, in which case the developer may not realize that they're supposed to be making those payments and are no longer able to deficit fund because it's after turnover. So that's a big one that needs to be addressed, along with the architectural aspects and potentially the easement rights that the developer would retain, because there's still going to be impact on the common elements potentially with the ingress and egress and the construction activities that need to be addressed. Hopefully so that it's not going to impact the association and the members that are already living there. But if it does, there are certain things that we can do to help alleviate that. And Jim, do you have any specific things from a construction perspective on property issues with that?
Not really. I mean, you and I have lots of communities where we are actually litigating property damage claims, and the home builder is still on site building out later buildings or phases. And it's a delicate walk that we have to make with, prosecuting claims and also community governance and having new buildings going up that very well may likely do have construction defects, and having to contend with that eventuality at the same time. But, Adam hit on all the critical issues, and everything else that I would be concerned about from a risk management, claims prosecution, and property condition point of view is something that is going to exist, whether the builders are the same and you have ongoing construction, or if it's a different regime coming in and building. The biggest concern for me, having dealt with the issue, is just, are they building the same product? Are they complying with your governing documents or your development plan? Or is there a material deviation where the homes are not conforming? And do you have a concern with that? The property condition issues, we can take care of those without intervening early on. A home builder is not going to be particularly receptive to the membership, assuming the means and methods of construction in any event. And that's not probably a productive route to go. It's more about understanding your rights and making sure that if there's a change in developers, what the successor is doing and how they will be accountable to the community, and what the predecessor might have, what type of lingering obligations or liability to the community the successor may have, or the predecessor may also have.
Okay, excellent. Last question, I promise. This is actually going back to our committee's Adam question, and it's asking, can we dismantle and rebuild? They're saying the ACB committee, so I'm assuming that's like an ARC committee. Can you just touch on that real quick? And then I promise we're all done with the questions.
Yeah, and I'll keep this one short too, and I appreciate those that have hung around. The ACB, again, architectural committee, I would assume, and it depends on your governing documents is the short answer. But if it follows the typical set of governing documents, those committee members serve at the pleasure of the board. So the board can remove those architectural committee members and replace them with new members that are more aligned with the board, newly elected board's values and vision in the community. And if on the off chance that they were talking about the architectural control rules, the actual guidelines for the community, again, based on your governing documents, it gets a little bit more tricky to just do away with all of those. Still, you typically have control to be able to change those moving forward, but you need to consider whether or not there are builders still in the community. Sometimes there are specific provisions that prevent a newly turned over association from applying those architectural review restrictions to the developer or builders that are still operating within the community. So it's really something that you need to review carefully in your governing documents.
Okay, excellent. Thank you so much. So Nagar and Jim and Adam, thank you so much for being here. We really, really appreciate it. I think we covered a lot of ground tonight and gave hopefully some great information. Any parting words anybody has?
Thanks so much. We really appreciate it, Fiona.
All right, thanks everybody. And thanks to our audience for joining. We really, really appreciate it. You guys have a great night. Stay safe out there.
Good night.
Bye-bye.